Alex here with another video on legal nuts and bolts. The topic is clear and convincing evidence. There's a couple of areas where I've seen this evidentiary standard arise. One of them is punitive damages. Basically, if you want to get an award of punitive damages, you have to show malice, oppression, or fraud by clear and convincing evidence. The other is a child custody or divorce style issue, which is domestic violence. In Nevada, you're disqualified from getting um, primary physical custody if you are found to have been the perpetrator of domestic violence. But there's a caveat: they have to show that you are a perpetrator of domestic violence by clear and convincing evidence. So what is this mysterious standard? A lot of people have heard the beyond a reasonable doubt burden of proof for like a criminal case, and quite a few people who've watched any kind of judge show like Judge Judy or the People's Court have heard the preponderance of the evidence standard, and which is applicable to child custody cases, divorce cases, and pretty much any other type of civil case. You really don't have to show that much more than the other person for the court to side with you and make a finding of fact in your favor in civil style cases, including child custody cases. There can be plenty of doubt there. If the court believes you more than them, and there's a lot of doubt, it doesn't matter. The court believes you more. That's preponderance of the evidence. That finding of fact will support the court's conclusion, and that's how you won or lost your case. Well, let's go with the child custody issue of domestic violence. That's not the case for when your ex accuses you of domestic violence. If your ex accuses you of domestic violence, they better have more than just a preponderance of the evidence, and there is not as much room for doubt as there would normally be on any other issue that the court would be looking at. I'll go ahead and read the definition of clear and convincing evidence in Nevada. I imagine this is the same everywhere. Nevada probably pulled it from some other state or from the federal courts or something. It's kind of a word salad, but I'll just go with it. According to the Nevada Supreme Court, clear and convincing evidence is satisfactory proof that is so strong and cogent as to satisfy the mind and conscience of a common man, and so to convince him that he would venture to act upon that conviction in matters of the highest concern and importance to his own interest. It need not possess such a degree of force as to be irresistible, but there must be evidence of tangible facts from which a legitimate inference may be drawn. Really, as I mentioned, a word salad, it doesn't tell you exactly some kind of magical formula to determine what clear and convincing evidence is, but at the very least, it does give me some ideas as to what it isn't. For example, I don't imagine that your word versus theirs is going to be enough to satisfy the burden of clear and convincing evidence. In other areas of the law, in a regular old civil lawsuit for money, as I mentioned, all the other child custody issues that come up in court that have to do with other issues, that happens all the time. It's your word versus your ex's. There's no witnesses. The judge believes one over the other. Sure, they might be wrong, but they have no idea. They don't know for sure. Since they believe this person more, they're just going to go with their gut, make a ruling on that, and it's supported by your ex's testimony. Even though it was her word versus yours, that testimony is substantial evidence. It'll be upheld on appeal. So you lost that issue. Well, if your ex accuses you of domestic violence, they better have a lot more than just their word versus yours, because unless your word is basically admitting to it. So, I mean, if it's your word versus theirs, and somewhere your word versus theirs, and somewhere in your statement you say something like, yeah, I punched her, it just wasn't that hard, well, that might qualify as clear and convincing evidence. But if you're denying it profusely and you're sounding like you know what you're talking about, you're not sounding like you're wishy-washy or you haven't been caught in like a bunch of lies, I can't imagine that her word versus yours is clear and convincing evidence. That would be something that I would challenge and take to the Supreme Court's attention, because if word versus word is good enough for clear and convincing evidence, then what's the point of even writing out that paragraph word salad definition for it? Why not just say it's the same thing as preponderance of the evidence? I don't know what the point of this video was going to be. I at least wanted to let people know that there was a higher standard in child custody cases and in other areas of the law, and what it was called, because a lot of people, as I mentioned, haven't heard of it. They've heard of preponderance of the evidence, they've heard of beyond reasonable doubt, but not many people have heard of clear and convincing evidence. And it's there, and I find it comforting to know that this Nevada legislature put that requirement in there for domestic violence, because I mean it gets thrown around a lot in child custody cases. When some people are desperate to have the custody of their kids, and they'll lie and say, you know what, he does beat me up, and you know, when it's just word versus word and so much is at stake, it just seems really, it cheapens the whole situation, you know. And this is sort of a bulwark that's there to protect the person who is accused of domestic violence. I mean, they're going to need more than that. And that goes to show you, if you're a victim of domestic violence, you need to keep in mind that this standard is going to be high. So by not calling the cops, by not getting pictures taken, by not reporting it, you're only doing yourself and your child a disservice, because in the future, if you need to bring it up in court and all you have is your word, as I mentioned, I don't think that's clear and convincing evidence, and I'm not sure what judge would. With that, I'll go ahead and end this video. I'll probably put a link to this case that I read the definition from, just in case anybody else wants to read it. And with that, I'll see you guys next time.